When you have issues or concerns with your child's assessment, IEP, offer of free appropriate public education, or with the provision of services to your child, there are a number of paths you can take to resolve the issue. First, I recommend discussing it either with your child's case manager, teacher, or any school official involved with your child's IEP. Principals and district-level administrators are also able to hear your concerns and attempt to resolve the issue. However, if you choose not to, there are official procedures granted to you in the IDEA Part B and California Education Codes for resolving those issues. They are known as mediation and alternative dispute resolution, due process rights, due process hearing, filing a written due process complaint, and filing a state compliance complaint. This section is an overview of these procedures and your rights throughout them. Mediation or alternative dispute resolution, or ADR, are less adversarial ways of resolving disputes. Both are voluntary ways of resolving a dispute, and so cannot be used to delay your right to a due process hearing if that is what you are seeking. You or the district can request mediation either before or after a written request for a due process hearing is made. ADR is local and is facilitated at the Napa-SELPA. A pre-hearing mediation conference, or mediation, is a means of resolving a dispute prior to a filing of a request for a due process hearing. It is an informal, non-adversarial way of coming to a solution to an issue surrounding the identification, assessment, or educational placement of your child, or their FAPE. This process is sometimes referred to as mediation only. If you want mediation, you must request it in writing to the Office of Administrative Hearings, or OAH, Special Education Division. Whoever submits the request to the OAH must provide copies of the request to other parties involved in the mediation. Once a request is received by the OAH, the mediation must be scheduled within 15 days and completed within 30 days, unless both parties agree to extend the timeline. All mediations are held at an agreed upon time and place, are facilitated by a trained administrative law judge, a neutral party with the goal of facilitating an agreement between the parties, and are confidential. You or the district can be accompanied by or advised by someone in the mediation who is not an attorney. You can, however, consult with an attorney before or after the mediation. A mediation is not required before requesting a due process hearing. If the mediation leads to a resolution of the dispute, a legally binding written agreement will be made and put into effect by all parties. If mediation does not lead to a satisfactory resolution for everyone, either party can further pursue a resolution through filing a due process request. Before a school district files a due process hearing request, the district must be given an opportunity to resolve the issue in a resolution session, which is a meeting between you and relevant IEP team members who have specific knowledge of the facts identified in the due process hearing request. When the district receives notice that you have requested a due process hearing, it must hold a resolution session within 15 days. In addition to relevant IEP team members, the session must include someone from the district who has decision-making authority. The district cannot have a lawyer present in the session unless you have your own lawyer present. In the session, you may discuss the issue detailed in and the facts forming the basis of the due process hearing request. The resolution session is designed to provide an early opportunity to resolve the concerns listed in your due process complaint. The resolution session is not required if you and the district agree to waive it in writing. If the district has not resolved the issue in your due process complaint within 30 days of filing, the due process hearing may occur. If the session leads to a resolution, you and the district must carry out a legally binding agreement. A due process complaint is a written complaint about the district that alleges the district failed to comply with the IDEA in a way that denies your child a FAPE. For example, a due process complaint could raise concerns regarding eligibility, assessments, services, placement, or implementation of the IEP. You have the right to a fair and just due process hearing. You have 2 years from the date of the alleged action that will form the basis of your due process complaint to file the request. What are my due process rights? You have the right to a fair and just administrative hearing at the California Department of Education before an administrative law judge knowledgeable of the laws governing special education and administrative hearings. Have an attorney and/or person who has knowledge about your child with special needs accompany and/or advise you during the hearing. Present evidence, written arguments, and oral arguments. Confront, cross-examine, and require witnesses to be present. Have a written, or if you would like, an electronic verbatim record of the hearing, including findings of fact and decisions. Have your child at the hearing. Have the hearing open or closed to the public. Have a copy of all documents, including assessments completed by the date of the hearing and related recommendations, as well as a list of witnesses who are planning to be at the hearing, and their general area of testimony within 5 business days before the hearing. Be informed by the other parties of the issues and their proposed resolutions to those issues at least 10 calendar days before the date of the hearing. Have an interpreter present. Request an extension of the hearing timeline. Have a mediation conference at any time during the due process hearing. Have notice that the other party plans to be represented by an attorney at least 10 days prior to the hearing. To seek more information or to file for mediation or a due process hearing, you or your representative must submit your request in writing to the Office of Administrative Hearings with attention to the Special Education Division at 2349 Gateway Oaks Drive, Suite 200, Sacramento, California, 95833-4231, or call for details at 916-263-0880. Or fax the request to 916-263-0890. The OAH has sample forms you can use to fill out your due process for hearing request at this website. Your request must include child's name, address of where the child lives, name of the school your child is attending, if the child is homeless, available contact information for the child and the name of the school they are attending, a description of the nature of the problem including facts relating to the problem and a proposed resolution. A copy of the due process hearing request must be provided to the other party. If involved in any administrative or judicial proceeding, your child must remain in the educational placement outlined in the last consented to IEP, unless you and the district come to a different arrangement. If your child has not yet been enrolled at CJUSD, enrollment will only occur with your consent while a dispute is active. The hearing decision is final and legally binding for both you and the district. Either party can appeal the decision by filing a civil action in state or federal court within 90 days of the hearing's final decision. Following a due process hearing, if you win all or some of your issues at the hearing, the court may decide to reimburse your lawyer's fees if they are considered reasonable. In administrative hearings, the cost of reasonable lawyer fees may also be reimbursed to you if both you and the district agree to it. Generally, the amount you are reimbursed for your lawyer's fees may be reduced in the court's decision if the court finds that you unreasonably delayed the final resolution of the due process issue. Your lawyer's fees are higher than the current rate of another lawyer in the community who has comparable skill, reputation, and experience to that of the lawyer you hired. The time spent in legal services provided were excessive, or your lawyer failed to provide the district with the appropriate information in the due process request notice. Lawyer fees related to IEP meetings may not be reimbursed unless the IEP meeting is held as a result of the due process hearing resolution or judicial action. A reimbursement of your lawyer's fees may be denied entirely if you reject a reasonable settlement offer made by the district 10 days before the hearing begins, and if the settlement you rejected is more favorable than the resolution finalized in the due process hearing. When you think that the district has violated federal or state special education laws or regulations, you may file what is called a state compliance complaint. Your written complaint must detail at least one violation of special education law that you think was made by the district. The violation you write about cannot have taken place more than 1 year from the date that California Department of Education receives it in the mail. A copy of your complaint must also be provided to the district at the same time you mail your complaint to the CDE. Your written complaint can be mailed to California Department of Education, Special Education Division, Procedural Safeguards Referral Service at 1430 North Street, Suite 2401, Sacramento, California 95814. If your complaint does not involve a violation of federal or state special education laws, consult our district's uniform complaint procedures by going to our district website or asking a school or district official. For more information about dispute resolution, contact the CDE, Special Education Division, Procedural Safeguards Referral Service by calling 800-926-0648 or fax them at 916-327-3704 or visit the CDE website.